So a very warm welcome to everyone joining today, and a special thank you to all our panelists and speakers. Garima Rathor from Microsoft, Norris Smile from London, Amit Khandelwal from Dubai. Once again, I would like to thank each one of you for taking time out to sort of join us today here and help us commemorate the Global Data Protection Day today. The significance of this day is, of course, highlighted by the fact, especially here in India, that this year we are going to actually be passing finally our data protection law. So hopefully, we should see that soon. And as such, I think we have a global audience as well, because this program is being live streamed on both Facebook and LinkedIn. And I think in that sense, it's a real pleasure for me to be hosting this. We would like to thank and acknowledge Policy Times as well as our other partners to have collaborated and helped us with this program. So without much ado, I would initiate this global virtual roundtable on data protection with specific regard to the digital data protection legislation 2022, which is currently being passed here in India. So just to give you a brief overview and the format that we will be following, the purpose today here is to look at the current draft legislation from a global perspective and to see how some of the contentious issues that are being dealt with in the current legislation or the draft have been taken care of either in Europe or globally, and learn from the best practices and also some of the mistakes that were made in terms of whether it was implementing the GDPR or some of the other legislations in Europe and elsewhere. With that, just to give you a brief background of the legislation itself here in India, I always say this is one of those pieces of legislation which has been one of the longest periods in time in the making. And if we would recall, frankly, the original IT Act in 2000 was enacted to allay fears with regard to breach of privacy or confidentiality issues as far as cross-border data transfers relating to call centers and the outsourcing industry were concerned. Because at that point of time, India was becoming a global powerhouse as far as outsourcing was concerned. And there were serious fears from US as well as European clients that we did not have a specific legislation dealing with any breaches. But unfortunately, it's been almost 20 odd years, and in fact, more than 20 years, and still we are grappling with the fact that we still have breaches and there's not proper specific legislation dealing with, data protection or privacy as such. So the current, of course, the draft has been in the making for almost now 4 years, and it was put in motion after the Supreme Court passed the Puthaswamy judgment, wherein there was a specific direction to the Indian government to frame a specific data protection law, as that was the judgment in which here in India the right to privacy was recognized for the first time. And in that sense, I think we had multiple drafts as well. So this is the second draft which has been circulated for consultation. And of course, there has been a lot of contentious issues as far as the draft itself is concerned. It has been revised multiple times. There have been multiple consultations as well. And there has been a lot of industry pushback as well on some of the issues, especially relating to cross-border data transfers or data localization issue. So I think without much ado, I would probably initiate the panel, and I think we can, in fact, take up the issue of data localization and cross-border data transfers as one of the first aspects. So here, may I invite Garima Rathor, one of my esteemed colleagues. She's heading the policy division at Microsoft here in India, to probably share some of her views on what she thinks about the current draft and specifically the provisions relating to the same. Garima, over to you.
Thank you so much, Salman. And firstly, before I get into the details of the draft bill itself, I think I'd like to thank you, your entire team in the Policy Times for actually putting this discussion together. Because as you said, this is actually very timely. The consultation on the draft has just gotten over a couple of weeks ago, and we know that the government intends to introduce it perhaps in the upcoming monsoon session. And just because the consultation is over does not mean we've reached the finish line. There's a lot to be done between now to the bill actually being introduced in the parliament. So it's great to see how these discussions are ongoing, and thanks to you and your team to actually make sure that the discussions are relevant and we keep pressing on the important issues that need to be considered before we actually see the final version of the bill. Now coming to our broad comments on the draft that we saw itself. So I'll actually start with giving credit where it's due, because I think it was really an act of wisdom by the government of India when they withdrew the JPC version of the bill from the parliament. And the fact that they agreed to go back to the drawing board to reconsider several provisions, given the kind of feedback they had from this industry, from the civil society, from academia, think tanks, I think that really speaks a lot about the intent of the government and the fact that they're actually looking at putting together a robust and cogent data protection and privacy framework for India. And I think in the version of the bill that we saw in November, there were certain really laudable provisions for which we need to congratulate the government of India, for which we need to congratulate METI. For example, the exclusion of non-personal data from the scope of the bill. I think it is a big win for the industry and the users alike, because that is a subject that is complex on its own accord, needs to be dealt with in much more detail. And we need to acknowledge the fact that the government took the feedback on that and actually acted on it, and that provision did not make itself into the bill at all. Apart from that, we of course seeing a version that's been cut down from over 100 sections to 30 sections now. So it provides for a much simpler reading for people like you and me, and for the users and consumers of India who are actually going through the bill. So similar to this, I think the overall vision of simplifying a data privacy protection framework for India, I think the government is really trying to live up to that commitment. And of course, I think something that the government has been really appreciated for is also the fact that they've come out with a principles-based framework as opposed to being extremely prescriptive at this time. And we also think to a certain extent that is the way to go about it, because a principle-based policy framework only will be able to keep at par with the pace at which technology is evolving. So I think overall the framework, the kind of bigger picture is in the right direction. But having said that, that also presents challenges of its own. And what we have realized is that right now, the bill is inching too much towards just following a principles-based framework. And we are not seeing as many specifics actually coming out in the bill. So I think a lot has been left to rulemaking later, the process of going into subordinate legislations. And that does not give the adequate amount of clarity for the industry and for businesses to prepare themselves for readiness and compliance when the bill actually comes into effect. So there's a lot that has been left to subordinate legislation. And I think that really becomes a very critical point for the industry, for people who are going to adopt the bill, to be engaged in that process itself. So maybe right now, how we see it, this is actually the starting point. This is not the finish line. And we really hope that at the time when the bill is introduced in the parliament for the discussion, we see a lot more granularity in it so that we can actually opine on it and there can be a wider consultation on the rules itself. Coming to the specific point that you made on cross-border data transfers, I think there is generally a positive sentiment, because provisions like data localization and data mirroring that found their way in previous iterations of the bill, they're not there in the version that we saw in November. But having said that, I would like to approach it with cautious optimism, because there is the process of whitelisting effectively, of notifying countries that the government is looking at as the only mechanism for allowing cross-border data transfers. And while we think that is progressive thinking, that is good directional thinking from the government, we really believe that, one, that should not be the only mechanism for enabling cross-border data transfers. And a lot can actually be learned from perhaps the GDPR or other equivalent, I'm sure Norris will weigh in on that, where additional transfer mechanisms like binding corporate rules or standard contractual clauses are also recognized as lawful purposes for data transfers. And in addition to that, we also feel that the process of notifying countries, there are no more details about that for us to actually have a full thought on that. So we do not know that what are going to be the required factors for notification of countries. And in absence of those specifics, is the notification or whitelisting of countries then going to become more of a geopolitical issue than actually a technical issue, which it should be, given that we are talking about certain standards, certain safeguards in place. So we think that there needs to be more transparency, and there needs to be, of course, a greater consultation that the government should have with the industry, that how is this whitelisting process actually going to play out. And before the bill is introduced in the parliament, I think what would be great and what would give more predictability and avoid churn later would be the fact that the specific rules around whitelisting are added to the bill. And we see a list of whitelisted countries. Because imagine the kind of churn it would create for the industry if you whitelist countries on a piecemeal basis. It could perhaps be 10 countries are whitelisted, that effectively leaves the rest of the countries actually blacklisted. So you're not enabling cross-border data transfers to those countries and enabling only to a specific few countries. So I think there needs to be a more holistic approach when the government is thinking about whitelisting. And there definitely needs to be an ongoing dialogue with the industry to make sure that cross-border data transfers are not restricted later because of any challenges that could have been mitigated at the start itself. So I take a pause here. I'm sure the other panelists will have a lot to add, but for now, I think this is our overall view on the bill as such and on cross-border data transfer provisions.
Thank you so much, Garima. This was excellent, and some of the points that you have highlighted are really pertinent, and I'm sure like the other speakers would have their views to comment on that. I especially appreciate the fact that you have talked about subordinate legislation, because I fully agree that the bill, while it does give a broad framework, but a lot has been left unsaid. And that is where, as they say, devil lies in the details. So that's where I think the industry is more concerned and worried. And we have seen issues with subordinate legislation in the past, and more specifically, more recently, whether it's with regard to the certain notification or, in fact, the IT rules itself, that things left, not very clear or not defined, undefined, have caused a considerable problem and considerable friction within the industry. Even if I were to take the example of certain notification recently, I mean, it talks about reporting cyber incidences, but what specifically are cyber incidences? Because that's such a broad term that people are now grappling with reporting everything, and whether it's only specifically to India or for global organizations like Microsoft, any incident that happens globally, which has even a minor impact on Indian, the user base, has to be reported, and stuff like that does create a lot of concern. And we've been repeatedly approached by clients with regard to that effect. And in that sense, yes, I think it'd be a lot much better, as you suggested, to have more clarity on the subordinate legislation and the details before the bill is actually presented in the parliament and the government takes a look at it. But I do agree that we hats off to the current government and the drafting committee that has brought down the size of the bill and focused more on the broad framework rather than going too much into the issues that were involved earlier in the earlier drafts. Also, the fact that you talked about whitelisting and also about the consultation process, because that's another big concern, because they have not specified data transfers, or typically as in Europe you would have the data safe countries or the whitelisted countries, and I think you've rightly pointed out that it would be more a geopolitical issue rather than a technical issue, which it should be. And that's where I think I would like to sort of request Norris to come in and maybe share his views. Norris sort of represents the International Association of Privacy Professionals, which is one of the largest bodies of globally of privacy professionals, and he's very kindly agreed to join us today, and I would thank him once again. And Norris, we'd love to hear from you more specifically from a European and global perspective in terms of your experience, how similar issues with regard to data localization or with regard to whitelisting, or for that matter, cross-border data transfers has been dealt with. Because I know there had been a similar thought process and similar back and forth friction as far as the GDPR implementation was concerned, and we still have those issues. And of course, now after Brexit in the UK as well, there are extensive discussions in Indian government and the UK government have been talking about data cross-border transfer issues. Over to you, Norris.
Sure. Thank you very much, Salman. First and foremost, thank you very much to the Policy Times for your leadership, organization, and Salman to invite me to share insights, not only from the global perspective, but also comparatively with some of the jurisdictions that sometimes, we might overlook. The market has been looking into the UK, Europe, as like the gold standard. But at times, when you compare and contrast some of the jurisdictions that are understated, you realize that some of the areas, some of the provisions are slightly better as compared to the UK or even, GDPR. I will explain a little bit more, later on that. I'm not representing, the IPP as an official capacity. So my views is very much my individual views. This is a caveat, as always, having a little background, we put caveat in our view. So that anyone should not actually quote my quotation said IPP says this. Of course, being an European advisory board member of IPP, one of the areas that we have been looking into is to listen from the market, listen from multinationals, and also listen from regulators, and also listen from outside European regulators and engagement. Prior to the current role, I was also the former IPP Asia Advisory Board, the inaugural Asia Advisory Board, where we actually tried to understand at the point of time, prior to the current, India bill, digital personal bill, there was lots of conversation of the IT Act, and at the time, Singapore has actually passed the law in relation to the PDPA 2010, and now it's been amended, PDPA 2020. And we look into Hong Kong as well. So there are lots of comparative analysis between Asia and Europe, Asia and UK, UK and the rest of the world, UK and the EEA, European Economic Areas. So I think to give some reflection and lessons learned for the past 4 years of the GDPR enforcement, I think the beauty of what exactly India is doing is that India is observing and listening, and also at one point of time, have a setback to actually understand what went wrong with the EU, right? And what went wrong, with some of these negotiations, even lobbying, and as well as amendments, of the current bill. So I've been observing the development in India for the past 4 years now. I mean, thanks to Salman, he has been me learning and relearning and refreshing, the development, which is very, very interesting in a way. And I think some of the lessons that India are currently, learning and relearning are partly like what GDPR prior to the enforcement, the current bill was actually drafted, 4 years ago. Because on the one hand, there's a lot of lobbying. On the other hand, there's a lot of negotiation and renegotiation. And also, whenever there's a change of leadership, there's a change of a little bit of here and there of the provisions. I think there's a similarity there, So I think it's common. It's not just, in the context of GDPR or in the context of India, but also other jurisdictions around the world. And that's actually where one of the key areas and key issues that is still undergoing until today of the GDPR enforcement is the global data transfer, data localization, because it's interrelated to one to another, right? I really love, when Garima mentioned about whitelist, blacklist, localization, because when you tell this to people who are not lawyers, when you tell this to the people who are in marketing, when you tell this to people who are in HR, when you tell this to people who are even, not privacy professional, in a very simple language, okay, do they understand what exactly this data localization is all about? They might actually respond in a different way, right? Because sometimes when we are unable to articulate the complexity of the privacy provisions, security provisions to a layman, to non-lawyers, to non-privacy professional, operationally is not easy. Operationally, and also to improve the transfer mechanism is not easy. So there are two key points I would like to actually share with the audience, globally, right? I mean, I think, most of the audience might be from India or Asia, or perhaps, listen remotely from elsewhere around the world. The first is, when you look into the UK position post-Brexit now, John Edwards is the current commissioner. He has actually, worked very closely with DCMS in relation to the data strategy. What is exactly the UK's leadership in terms of, the post-Brexit? And there are quite a number of initiatives that have been done and still ongoing, which is a data partnership between one jurisdiction to another jurisdiction. It's very bilateral. They look into the level of, the transfer, and then from the bigger picture perspective, they look into the economy and as well as the infrastructure. They look into the bilateral investment. They look into the onward kind of transfer, from that particular country to another third country, because the risk is more towards the third countries, right? Because you don't know whether those data will be further or onward transfer to the rest of the world, which might have adequate legislation within a whitelist in the UK perspective, or which also might have the whitelist, kind of provision from the European Commission perspective, and which is quite interesting because sometimes commentators, academics, professionals, lawyers, they overlook that sometimes some jurisdictions, they have their own whitelist, even though that jurisdiction is not whitelist under the European Commission, which is very interesting. So we don't know what is the criteria of that particular jurisdiction, which has the whitelist criteria, and telling the other jurisdictions that, hey, you have to comply with our whitelist kind of mechanism, which is very interesting, to listen this. And it's not debated, because it's very one-sided, or because people thought that, yes, GDPR is, the gold standard. Okay, you have to comply. If you're not compliant, we won't actually deal business with you. All right, okay, that is very straightforward from the compliance perspective. But because of the geopolitical, element, it's what Garima highlighted, because of the way data flows in a virtual environment, in a cloud environment, even in a very complex, sophisticated, emerging technologies environment, where the combination of blockchain, the ledger platform, and AI environment, and quantum computing, it makes more complicated, even for startup and SMEs to actually understand what does it mean to them. Okay, when it comes to whitelist and blacklist, right? So the data strategy that the ICO has been advocating right now is that, right, to look into the focus priorities between jurisdiction and the jurisdiction from the economical point of view, and also in relation to how exactly they need to really reduce the bureaucratic process, right? Okay, when I say bureaucratic process means there are lots of lessons learned from, the GDPR, the one-stop shop. I mean, for those who are very familiar, one-stop shop means that, if you deal with the lead authority, concerned lead authority, with the DPA in a particular member state, there might be certain element of coordinated mechanism, simple, kind of coordination between the DPAs in the member states. But in reality, one-stop shop is not that one-stop shop. It depends. It depends on the focus, it depends on the case, it depends on the scenario, and it depends on the complexity of that particular cases. All right. So that's just the first point on the ICO leadership when it comes to data strategy, that in relation to the bilateral kind of arrangement and agreement with government to government, particularly India, and as well as Singapore and Hong Kong. And in fact, which is the second point, the whitelist so far, which the ICO, the UK, has been advocating, is very much like a data bridge kind of mechanism. Okay, data bridge is a very common technical language, in IT, right? So what data bridge means that, so last year, ICO, the UK, actually has signed and also agreed that South Korea is considered like a whitelist within the data bridge arrangement. And there's also an ongoing initiative between the UK and as well as DIFC, as part of that ongoing conversation. And there's also in the future, the UK is looking towards India, which is also an important jurisdiction, important market, Brazil, Singapore, and as well as, of course, Japan, because Japan is actually part, of that particular, whitelist from the European Commission. So there's some similarities that you can see what exactly the post-Brexit UK have been doing in relation to global data transfer, and also in relation to make it a little bit different by having the UK gravitas, UK persona. As always, so there's always something very new about UK. That's why they coined the word Brexit. That's why they coined the word data breach. That's why they coined the word, a different kind of words. And I'm not surprised they will actually coin new words, in the future. So last one point, so in the interest of time. So last evening, because of this webinar, I actually read 4 annual reports. The Irish Commission annual report, the ICO annual report, the European Data Protection Board annual report, and the European Data Protection Supervisor annual report. These are the 4 main reports that you actually must read if you want to be a top-notch, world-class privacy professional. Sorry, I have to say this, because from there, you can actually really appreciate the case studies, the nature of the enforcement, the nature of investigation, and then some of the court cases, right, that have been highlighted in the annual report, and also the challenges in terms of technology, innovation, the spending. Because from there, you can actually articulate and to cascade it to your organization. Oh, these are actually the regulatory focus. This actually will be the angle that they might continue for 2023 onwards. And this is something that you need to think about. And amongst others, the similarity that I've actually observed and listened and also appreciate and reappreciate is data transfer, data localization. It's a still work in progress. And I think watch this space. This will be a very, very big area, very, very big thing, in 2023 onwards. And in fact, the post-RAM, kind of decision or judgment really pushed the UK to really develop or have actually launched the Transfer Impact Assessment, TIA, they call it, which also aligned to Article 46 of the GDPR, in addition to other transfer mechanisms, what Gary might say, whether it's a BCR or any kind of grounds of transfer. So the risk assessment is the key, and in order to articulate this to the stakeholders, simplify your language, articulate your story, and tell to the stakeholders globally like you're teaching school children. Sorry, I have to say that because I think it's important, to articulate that in a very simple language, right? I think that's actually the view and lens, at this juncture, Salman.
Thank you so much, Norris. And this is really, really very helpful. And frankly, I must appreciate the simple language in which you put it across and some of the very complex aspects revolving around data, cross-border data transfers or data protection, generally from a global perspective. I also sort of really appreciate the fact that you took the time out last night to read through all these 4 reports, which is probably, I think, quite in depth and probably, it must have taken substantial time of yours. So thank you again for that. But I think the fact that you've talked about the simplicity, and I think this was something that was highlighted by Garima as well when she mentioned about the granularity and she mentioned about the subordinate legislation. That's kind of the essence, and in that sense, I mean, it's kind of really interesting how global regulators or different countries are looking at this from a global data transfer perspective. And I know for a fact, since we do a relatively good amount of work in the Middle East to one of our sister concerns, that several jurisdictions in the GCC area are actually, on the same path as India, or probably a little much further ahead, while some of them have passed data protection legislations and implemented them. Saudi Arabia and UAE are in the process. They have actually passed the legislation but not implemented them as such, and we are still waiting for implementing regulations. So on this front, and since we have the pleasure of having Amit here, who has cross-border GCC experience dealing with such issues on a GCC and Africa MENA region basis, I think I'll sort of request him to sort of share some of his experiences in that regard, and also maybe comments on how probably India could sort of deal with some of the challenges in this regard, learning from experiences in that region. So with that, Amit, I'll hand over to you. Over to you.
Thank you, Salman, for organizing such a good event along with the Policy Times. I'm very grateful for inviting me to speak on this opportunity. You rightly said that Middle East and Africa, there are many countries who are in the process of enacting regulations, implementing regulations, as you say, subordinate regulations to the main law which they have passed with regards to data privacy. And there are some countries in Africa, notably countries like Nigeria, Uganda, Kenya, they are way ahead in terms of enactment of the law and regulations with regards to data privacy. So it must be surprising for some of your viewers to know that there are African countries who have enacted laws like 10 years back. For example, in South Africa, personal data law was passed in 2014. Though the real implementation, the implementing regulations were out a couple of years back only. But so we should understand that while it's a great move from the Indian government, but it is definitely late, and it has been hampering a lot of businesses who have cross-border implications and who are working in multi-jurisdiction environment. It was impacting their businesses a lot. So it's a welcome step, late, but I would say that we should tread this as a caution, because when regulators, when they start looking at enacting, implementing regulations, that's when things may go wrong. They may overcomplicate things, the environment. They may leave many things which are important for businesses and consumers as such, which they may not touch upon, and that may bring a lot of ambiguity for them rather than clarity, which is the need of the day. So this public consultation is a great step forward, even when the subordinate legislation is planning to be out. At that time, also I would urge the government and the stakeholders involved in the consultation process to urge the government to open up the consultation process so that the right steps can be taken from the first go onwards, so that there is no need to do amendments and other things which could impact the industry. As you rightly said, countries like UAE and Saudi, we have enacted the regulations, but the implementing regulations have become a challenge. It's been, for UAE, it's been more than a year that the implementing regulations have not been out. Consultation was started privately, I would say, but it is a complex area. There are many challenges, many stakeholders involved, many industries who would want to guide the regulators in a particular way. So regulators are listening to everybody to see if they can make most of them happy, if not everybody happy. So India being such a large country, I'm sure it will take probably in its own time and after the consultation process is over. But what I want to say is that since the ball has been rolling, it'll be now upon the organizations to start their process, thinking process on. They should start sensitizing their senior management, their boards, that this is an important area which now can no more be neglected. They should start putting in budgets and teams in place to make sure that the moment the law is passed and the regulations are in, that you are well equipped to start the compliance process. Some companies who are multinational companies would already have some departments already been set up, data privacy departments. DPOs have already been appointed, probably at a global level or regional levels. So those DPOs and those companies should start thinking about how to initiate the data flow and data mapping processes, because it's very important to know for an organization where their personal data is lying, what systems are being impacted, what their technical and organizational measures they are implementing to safeguard, what is the requirements, what is the general standard requirement of their industry. So all of this data collection is very, very important, and they can help the organization by starting this process early.
Excellent, excellent. Thank you so much, Amit. Once again, very timely and very deep observations, especially like the fact that you highlighted aspects relating to the fact that certain African countries have taken lead as far as data protection is concerned. And the example of South Africa that you highlighted was really an eye opener for me as well. I mean, they enacted their legislation almost 10 years ago. It kind of shows how far back we are lagging just because of the legislative process, the slow legislative process here in India. And I think it also relates to what Norris said, the fact that we can learn a lot from some of the smaller countries and some of the, countries that are normally not on the radar. And we kind of always look up to Europe and US as far as the gold standard is concerned. So I think there is a lot to learn, and I think probably it's events like these where we can freely share information and experiences that kind of drive home the point. On that front, and also with regard to what you said subsequently in relation to sensitization, how organizations can prepare themselves in anticipation of the law and the subordinate legislation that is going to be implemented. I think the aspects relating to what companies are doing in the GCC region or what the companies are doing in Dubai and Saudi Arabia, relating to sensitization, relating to training, relating to start preparing their checklists, their implementation mechanisms, is something that again Indian companies can sort of learn from the region and probably start looking at it more seriously where the issues are concerned. However, I mean, I'm reminded of the fact that Garima mentioned about subordinate legislation and also about the harmonization of sectoral laws, because a lot of times, and especially we have witnessed this previously as well with regard to the IT Act and some of the other legislations in India, the telecom regulation, the RBI directives. I mean, I remember the fact that there were 6 different, at one point of time, there were 6 different legislations in India talking about the level of encryption that could be used. And they were just juxtaposed to each other. While RBI was advocating 256-bit encryption for all kind of banking or financial communication, the IT Act was, prescribing much lesser, level of encryption. Similarly, SEBI was prescribing another limit of encryption, and the telecom laws or the telecom license agreement was actually, penalizing if organizations were using more than 69-bit of encryption without seeking prior approval from the government. So, I mean, we had a situation where, there were corporates who were using, BlackBerry, server or enterprise version of the server for corporate communications, enterprise communication, and they were, at times being considered as falling foul of the law because they had not sought specific approval of the government. So in that kind of a situation, when we talk about harmonization of sectoral laws, I think that is the need of the hour. And on that point, I'll request Garima to share some of her thoughts in terms of what practically we are facing as far as the technology laws are concerned, and more specifically, the data protection legislation that is currently being debated.
No, absolutely. I
Cool.
think that's a very pertinent point. Because right now, if you see, and by the way, just taking a step back, I think there have been several instances in the past, even when you spoke about the certain breach notifications, you're mentioning about the IT rules, the amendments that have been coming out, when various laws have actually been in conflict with each other. There hasn't been as much of a regulator to regulator discussion or a government to regulator discussion. And what ends up happening is that the onus then is passed on to the industry itself, to companies to make a decision on that. And I can actually vouch for the fact that bigger organizations like ours itself, like Microsoft, struggle a lot in those kind of scenarios. So I can only, and this is when these organizations have a relatively higher capacity to at least make those decisions. We can consult people, we can reach out to our lawyers, we can reach out to our teams. But given that we have also faced severe challenges when it's come to such situations in the past, I can only imagine the kind of impact it has on smaller and medium enterprises and startups. Like India is aspiring to be the biggest startup ecosystem in the world. And Microsoft actually works with the startup ecosystem in many different capacities. And we know the kind of challenge that they have faced because of these conflicting laws that come into place. And ultimately, you have to decide that what do you actually go by? How do you make those decisions? Because what happens is a lot of times the decisions that you make, whether it's in terms of compliance or whether it's in terms of implementing a certain provision, they actually require you to change a fundamental design of your product or re-engineer your systems, re-engineer your architecture. And these are not decisions that can be just made overnight. You need a certain level of policy predictability, a certainty to actually be able to make those decisions. And that is agnostic of all organizations, whether big or small. And I think this is also another crossroads that the industry is finding itself at when we look at the data protection bill itself, because we've seen that there is a section on harmonization that actually says that if there is a conflicting act or a conflicting regulation, then it's actually going to be the provisions of this particular act, the Data Protection Act, when it gets finalized, that should prevail. But what does that mean in terms of practical execution? How will that play out? I think those details are not clear at all. And one of the biggest examples is actually the RBI data localization mandate that came out a couple of years ago. RBI is like one of the strongest sectoral regulator in India. And I think they did not mince any words in saying that all payment system operators actually have to store their data in India. So it was a localization mandate. And it created a lot of churn for the industry. It had a downstream impact on a lot of fintech startups also after it was implemented. But that is the scenario that we know of today, that payment system operators have to localize their data. But when the bill comes out and says that cross-border data transfers will be enabled to these whitelisted countries or to countries that are notified by the government, does that mean that the RBI data localization mandate then does not hold true for those particular countries, those particular jurisdictions? Does that mean that, companies have to go back to their drawing board now to figure out data flows to these whitelisted jurisdictions where data technically has been localized right now, payments data as per RBI's mandate? So this is actually a live example of where we're seeing discord between two regulations, one in the form of a proposed draft and one is a sectoral regulation that's already been in play for a couple of years. And I know for a fact that this issue has been raised by the industry in front of the ministers, and it has been taken across different forums. And what we have heard so far is that there will be harmonization eventually. The government will be talking to RBI or other regulators as may be needed. But what will that look like? Does it mean that the industry needs to start taking certain steps right now itself? I don't think we're clear on those at all. And it was interesting, like when you use the word anticipation, that, we are anticipating a lot of things when it comes to subordinate legislations, when it goes to the rulemaking process. Now, the part is that while we can discuss a lot of things and anticipate what's going to happen, the ground reality is that business decisions do not get made based on anticipation or based on what we predict is going to happen. You actually need a certain level of granularity and you need a certain level of predictability for any sized company to make those decisions of what is the company going to look like, what is the product going to look like, how are you going to be, using data, leveraging data in the context of consumers. So I think that level of specificity, till the time we do not have, I know you and I cannot go back to our business teams, and say that you need to make these changes in order to be ready for compliance. So I think that is a far stretch till the time we do not see specificity coming out. And I think along with that, the harmonization of this bill with other sectoral laws will be very important before there is any kind of compliance runway that is given to companies to comply with the act as and when we see it.
Excellent. Garima, I think some of the points that you've highlighted, and I'm very, very excited the fact that you gave RBI's example, and more specifically with regard to the RBI's mandate. Now, if you sort of look at it from what is currently happening in India, of course, the data localization mandate separately, till at least a few months ago, we were just talking about Indian, payments and Indian, financial data. But now, RBI itself, for that matter, has allowed global UPI payments. So there are 8 countries that have been permitted. So you can have UPI payments cross-border. So when you are permitting cross-border UPI payments, that financial data relating to the payers or the payees and all that data, where are you going to, are you saying that you're going to store all that data here in India? Then there is an issue about the local laws of those jurisdictions, which require that data to be stored there. And obviously, those data subjects are not your, subjects, or they are not residents in India. So, how far that is going to be practically possible? How's the industry or the fintech players, or for that matter, some of the startups that are doing some amazing work in fintech, in anticipation of some of the business that is going to come from this, is going to sort of, live up to that challenge, because it is going to pose a major practical challenge, and not just only for those companies, but I think for the regulator himself, because you have 2 different, situations. So 1 or 2 year ago notification, and now you are allowing international cross-border UPI payments. And then also you have had RBI specifically allowing other governments to use certain banking, infrastructure for their payments, international payments in Indian rupee. So it's no longer the same, financial landscape that we're talking about, and it has evolved very quickly over the last especially in the last 1 year. So I think that's a very ideal example, and it drives home the point that there has to be a lot of harmonization before we really look at, how the law is going to pan out. And industry has very valid concerns, and the fact that you rightly highlighted, it's not just about bigger companies; it's about the startup ecosystem. When you're talking about being a global, guru as far as the startup ecosystem is concerned, you have to look at those fintech and startup companies and ensure that you're not, nipping in the bud the innovation that is happening, because those guys are actually working to innovate on the go. And then you have a new regulation coming in that just sort of, just smashes through the whole concept and creates such a huge compliance cost that they're not even able to bear for that matter. And I think this issue gets highlighted repeatedly, whether it's with regard to the certain notifications, the storage of data in India, or just the storage requirements as far as some of the regulations are concerned. Because it's easier to say that you need to store data of the last 5 years or 6 years, but who's going to pay for that storage cost, and who's going to be responsible for the security of that is especially for a smaller startup or a fintech company, it's a huge challenge. So I really appreciate the fact, and frankly, as you said, it's taking those people back to the drawing board, and at times, it's sort of putting them in a very precarious situation where they have to maybe at times even modify the business model because of a new regulation that has come in place. So on that front, I think I would like to draw in Norris and try and sort of pick his brains on how this challenge has been dealt with, especially in Europe or in other parts of the world, because I'm sure we would have had similar situations, especially from a global perspective and especially from multinational perspective. Norris, what do you think? on this issue?
Sure. Thanks very much, Salman. I think this is a very indispensable question, which is still an ongoing concern, not just from the perspective of multinationals, startup, small businesses, but even from regulators as well, and even sector-specific regulators, not just in the context of the EU, European Economic Area, the UK, India, but also the rest of the world. So whenever I conducted a masterclass or workshop with C-suite investors, stakeholders, or even listening exercise with regulators and also key stakeholders, right? I always ask a very simple question, but very hard to answer, right? So the simple question is, what is the highest risk in your current environment? It's just a one-liner statement. So stakeholders actually responded in a very different angle. Where it's like a spider web, right? Okay, there's always interrelationship. Data is like everywhere. Data is messy, right? Whenever you look into every legislation around the world, sector specific or even non-sector specific, there's a data behind it, right? Doesn't matter whether this is sensitive data, filter. So we have to look into the bigger picture perspective, the risk perspective, start with that question. And then from that perspective, and then I ask the second question, when you say highest risk, okay, why do you actually highlight this as a highest risk given your current risk posture, risk environment, organizational environment, not only organizational environment, the market environment, the regulatory environment, the complexity of data interoperability, which is very complicated in the context of network, infrastructure, the model, business model, technology model, even targeted, privacy and security operating model, especially for multinational companies. Because at times, the bigger you are, the more silo you will be. Because it takes time for you to align and to cascade and then to really improve, recalibrate your activities on the ground. Because my lens is more from the operational perspective, the practical perspective. Because once you have identified, the highest risk, high risk processing activities, given all of the factors, then, all right, work with your legal team, work with your DPO, work with your general counsel, work with your external law firms, and work with all of these, key important advisors, and then articulate it in a way that, right, okay, we have too many things here on our plate right now based on the highest risk activities here, right? Okay, so what exactly GDPR says? Okay, maybe this will be like sign of legal advice from your lawyer, okay, maybe like 5 or 6 areas. And maybe the council in India says this would be this position in India, and the council outside India, maybe China or Singapore, or even global financial services center in the world, like New York and Zurich, or even Frankfurt, and even the key fintech hub, startup hub will have different kind of position, right? So this is where the challenge is to really align and to articulate and to tell that, all right, we have to be very strategic, we have to be very tactical, at the same time, we want business as usual. And this is actually where the challenge is, when it comes to translating the complexity of harmonization, the complexity of data interoperability, and also translating the potential risk that might trigger from the data interoperability in the day-to-day context, right? So there's one angle. Another angle that we have seen a lot, in the market, especially here in the UK and Europe and the US, is that, right, okay, put aside privacy. It's not because we are it's too complicated, because only lawyers could understand. Why not we actually look into cybersecurity, right? Why not we look into controls? Why not we look into standard? Okay, so recently the ISO has actually launched privacy by design, as part of ISO extension, which is great news, which is more like a great news for the new year. Okay, I like when Garma mentioned about cautious optimism, because it's actually the key word now in the new year. In Davos, they highlight the cautious optimism. Even the key CEOs mentioned cautious optimism. For me, I would like to rephrase the word cautious tactical optimism, right? So when I say tactical optimism, is okay, there is element of positivity, but at the same time, you have to be very agile and you have to cherry pick which element that you need to focus first, one step at a time, one day at a time, 1 month at a time, and develop and improve it. Because otherwise, you'll be bombarded down with too much information, legal information, data information, technology information, and you're at a crossroads. You don't know what to do. You don't know how to start. You don't know how to tell, to your partners, to the key vendors. So linking back to my earlier point, Salman, which is, the controls, NIST framework in the US, they've just launched the AI, element within this framework, which is great because globally, in fact, every day when I actually switch on my LinkedIn, people are talking about ChatGPT. Wow, okay. Do you know that the more you put data in ChatGPT, they'll be very happy because you put your data there. And that's how AI works. And luckily, I don't put anything on ChatGPT because that's the business model, because it's triggered by algorithm, right? So because this algorithm is very unique and they've researched this for the past maybe more than 10 years silently, and people now have a hype. Wow, does ChatGPT will take over our job, Salman, Garima, and as well as Amit, or even listeners on today? No, because there's still a lot of work to do. But what they want is your data, your question, so that they can improve the platform, right? But I'm not saying anything about it, but I think that's actually the challenge that we are seeing, because innovation is great, innovation is superb, but I think the point here is that for any kind of innovative technology, disruptive technology to really, really thrive, I know this is a little bit back to basic. Embed the privacy by design, security by design from the beginning as part of the process, right? Tell to the algorithm coders, tell to this, technical people, hey guys, these are your flow. Do you know what privacy is all about? In a very simple language to the coders, the algorithm, privacy engineers, security engineers, right? Walk through with me. How do you actually do this in a very simple language to me? Because I'm a lawyer by background. That's how I actually ask the question, to all the key stakeholders. So when you're able to really align and harmonize controls, all the security controls, not just NIST, not just privacy by design, security by design, or any defensible control that can stress test your environment, multi-layered, encryption, whatever, then that will actually really back up, the gap, the gray areas, in the context of the interpretation of harmonization from the legal perspective. Because this is actually where you can minimize your risk, you can develop a very powerful and impactful data defensible position and achieve certain level of trust, to your stakeholders, to your third parties, and as well as to the people that you are actually having conversation with. Because as you know, cybersecurity has been championing zero trust, right? Zero trust is important, but at the same time, right, depending upon your risk posture of organization, depending upon your focus in a high risk, and this is something which you need to really focus on. Another quick point, Salman, before ask question to Amit, is that a while ago, before we kick off this webinar, whilst having breakfast, I actually read a very interesting, Personal Data Protection Commission of Singapore achievement for the past 10 years, right? As you know, Singapore, they passed a law 10 years ago, right? What they have done is dynamic. What they have done is wow, it's within 10 years, they achieved a lot, right? Of course, Singapore is a small member state, like a Swiss of Asia, and the fact that it's really integrated with all of the stakeholders, not just in the context of Singapore, but also in the context of ASEAN member states, right? Not only in the context of ASEAN member states, but also having a bilateral kind of MOU, with ICO, with the commissioner in Hong Kong, and also National Privacy Commission in the Philippines, and get involved, with lots of initiatives that are still ongoing gray areas among the APAC, privacy commissioners, within the APAC itself. So one of the things that they are keeping on engaging is harmonization, right? This refers to what, Garima said, right? In ASEAN, there is ASEAN Data Governance Framework. Framework is a framework, it's not binding, but is either you can take it, cherry pick it, and you apply it in your organization, right? So if you go to the Personal Data Protection Commission website in Singapore, there are quite a number of useful technical guidance or technical kind of advisory document, which is so easy to understand. When I say so easy, it's actually my standard. I'm not sure because there are quite a number of different kind of audience in the webinar. And amongst that is about blockchain. Amongst that is about AI, and amongst that is about things that are really, really trendy, which I think that, maybe as part of the harmonization, if you're a DPO covering India or MENA region, GCC region, maybe cherry pick one or two great things about Singapore, the PDPC have done when it comes to harmonization. And of course, there is always a bias. We love to see the West. We love to actually adopt, this is what UK says, this is what actually, GDPR says, this is what part of the sectoral laws in the US says, or part of the 50 states of the security breach notification in the US says. But sometimes you overlook the beauty of the unique kind of approaches or hybrid approaches in outside the Western jurisdiction. And I'm not saying this because, I'm advocating that there's always bias. No, I think if you really come up with a very hybrid, very agile, way to approach harmonization, it might work, and you have to improve it. You keep on realigning it because there's no such thing as okay, this is fixed. That's it. You can't change this, forever. Especially when you deal with data every single second in your business here.
Thank you so much, Norris. I think that was very insightful and very, I would say, very informative and from the perspective of the global experiences and what probably companies can learn from each other and what we can learn from the different jurisdictions. And I really appreciate the point that you made about Singapore, looking at it and learning from them rather than just trying to blindly imitate the West. I think that kind of drives home the point. On that, I'm reminded of the fact that Amit, you had recently, discussed with me, and we talked about, how organizations, what steps organizations need to take when they're considering putting in place or preparing their internal data privacy or data protection policies or data protection frameworks. And I think at this juncture, it might be really very interesting, especially in light of what Norris talked about, the silos and the more specifically the recent ISO privacy by design standard, and also the risk matrix that he started the discussion with. What do you think could be a good start for organizations here in India who are looking at preparing themselves from the perspective of being ready for a possible compliance regime under the new data protection legislation, and how best they can prepare to have a proper data protection framework within the organization? Over to you, Amit.
So, I think one of the first important aspect to take care of, as Garima was highlighting, that the company should be involved in the decision-making process. The consultation process is on. Each company will have their own unique issues. Their industry will have their own unique problems or challenges to take care of. So as of now, I think industry should make sure that they are actively involved rather than being passive about it, and later on criticize that something was not ignored. Was ignored and was not considered. So it's important at this step, at this juncture, to be actively involved, talk to the stakeholders, talk to your peers in the industry, even though they may be competitors. But there are industry bodies. You should be raising these issues as an industry as such, and then raise this with the relevant stakeholders at the government level, I would say. So that's the first and foremost step. When you talk about external factors are concerned, internally, the company should start looking at what is the right model for them to make sure whenever this law is passed and subordinate legislations are in place, how they would want themselves to be structured. What is the best way which works for them which does not disrupt the business as such, but also ensures that the requirements of the law are practically implemented on the ground, and it is not within some data privacy department, or it's with legal department only. So it's a collective responsibility. So they have to think about a structure which focuses on this collective responsibility. And they should start, as I said earlier, they should start sensitizing from the top. The board should be made aware very soon that this is an upcoming regulation. This regulation and their implications should be talked about in regulatory management committee meetings, in board meetings, in their audit committee meetings, that this is an important legislation which will have a huge impact on all the industries, and especially industries which are data driven. You talk about financial services sector, they're all data driven. Payments industries, they're all data driven. So wherever data is involved, wherever you are collecting or talking to individuals, I'm sure this regulation will touch upon or will have an implication on you. So message to the top, sensitizing the top management is very, very crucial. Taking their buy-in is very important. Bringing them on board is very important. Making them aware of their own responsibilities, because ultimately they are the ones who will be responsible whenever there is a breach or whenever there is a non-compliance issue at the organization. So they should be made well aware of how things are progressing, what are the challenges faced by other organizations in the past. And then within the department, data privacy teams, if there are any, and if not, the legal team can take the lead, compliance teams can take the lead to orient themselves, because it's a new thing in India. They may not have precedents. They may not have qualified, fully qualified individuals. So they should try and start, gaining knowledge, experience through various trainings. IAPP, for example, has brilliant, training materials and courses which they can go through and, make them well aware as to what are the different aspects of, data privacy. And once that is in place, I think the next step would be to, put a data privacy framework in place for an organization, a framework which works, a framework which focus on collective responsibility, a framework which is which is sustainable, something which is auditable. That is the type of framework which I would recommend organizations should focus on. So I think, I know these steps will take a lot of time, a lot of efforts, and because of lack of regulation, certainty is definitely not there. But starting in advance is always good, rather than catching up from behind.
Well, thank you so much, Amit, for sharing those thoughts and frankly those suggestions for people to sort of pick on and start work. And on that, I think I realized that we have sort of overshot our time for the discussion. So I would like to open up the session for any quick Q&A if anybody has any questions. And if not, I would obviously request if any of you have any additional thoughts on any aspects that you would like to discuss or highlight, we can move on to that. So any questions? Do we have any queries or any questions specifically with regard to what's been discussed? I don't see any hands raised. So I think I'll probably, I remember, Norris, you suggested something when we were discussing the first time we discussed about this global roundtable. You mentioned about a data bridge, and you wanted to sort of talk about that, and also the continued risk theme, especially with respect to AI, that you wanted to discuss. I understand that that's something that we've not touched upon. So I would be very keen to hear about what you think about from the data bridge perspective, especially in cross-border data scenario and in the current globalized world. And also more, if you could shed some more light on from the perspective of continued risk theme.
Sure. Thank you very much, Solomon. I just want to reflect on one point which Amit excellently articulated about framework, because globally, there's no such thing like the perfect framework, right? Because it goes back to the culture, the DNA, organizational culture, and also the regulatory culture as well, of that particular market or jurisdiction wherever they operate. That links to the data bridge as a question, because it's an interrelationship somewhat between culture and as well as how do you really manage, the data, you protect the data. And I think knowing your data is important. I think that's actually the first kind of element, having that know your data campaign, right? So when we talk about data breach, just not just in the context of AI or non-AI, as you know, right? I mean, in the US, comparatively, it has been around for quite some time because they do have, all the states 50 security breach notification, and it's actually part of the, element that GDPR has embedded, for prior to the enforcement, 4 years ago. So throughout my flipping of the pages of the report, it is very interesting, Salman, Gariman, as well as Amit and everyone, especially the audience and listeners. The Irish Data Protection Commission is the busiest regulator, arguably in Europe and arguably in the world, because they received the percentage of data breaches almost more than 50%, right? I think you guys are fully aware. I won't mention names. I won't mention organizations, and it's so interesting to see that kind of traction and trajectory. And if I compare and contrast with the ICON report, is also quite the same, and especially during the pandemic, because there are lots of ransomware cases during the pandemic. It doesn't matter, whoever the hackers, coming from. So regulator was so busy, really, really addressing some of these data breach cases. So that's the first angle when I extracted, the intelligence and the data from the report. Secondly, which is very interesting and quite interesting, is that whenever you actually do an enforcement tracker from each of the cases, depending upon the quantification of the breach, because GDPR says 4% of the global annual turnover, but until today, there's no organization which has reached that 4%. I'm not expecting that. I would love to see one, no, but okay, this is more about that kind of negotiation, and as well as the outcome of investigation, especially from the regulators, together with the relevant organizations that are affected by the breach, together with the forensic investigators and even counsel, lawyers, DPOs, because there are too many stakeholders involved whenever there's a breach. And on top of that, which is very interesting, Salman, briefly, we are seeing the gradual rise of cyber insurance, data insurance, because this is actually an ongoing trend. Because on the one hand, whenever I actually ask the key question, to stakeholders, especially chief risk officers, or even DPO or general counsel or CISO, why do you buy cyber insurance? We have a huge infrastructure, we have a data center somewhere, and then it's more like having the lens of business interruption, insurance, rather than understanding the data taxonomy prior to purchasing that particular insurance, right? So this is still a lot of work to do when it comes to what exactly that you need to think about when you want to opt for cyber insurance. Yes, it will help you to transfer the risk when it comes to that kind of data breach, right? So you quickly, when you look into the AI lens, right, until today, in the market, especially in the UK and generally in the EU, we've not actually seen regulators' reaction or even data subjects' complaints about AI. I'm not surprised there will be, after the AI regulation, will be enforced, in the EU. And it's been very interesting to see the UK perspective, because at this juncture, the ICO is still deeply listening, from the key stakeholders, key innovators, companies that are investing in AI, and find a middle balance. It's not easy as a regulator, right? Because on one hand, you want to enforce the law, you want to administer the law. On the other hand, you want to be very friendly to the business, but you just realize that you need to protect the information rights. So interestingly, Salman and everyone, we've also learned that the ICO has been very active in relation to working very closely with other sector-specific regulators. This goes back to what Garima's point earlier about harmonization, but harmonization even amongst regulators. So ICO has been working very closely with the Financial Conduct Authority in the UK, which is actually the regulator for financial services, and also Office of Communication, which regulates some of the telecommunication activities, in the UK. Competition and Market Authority from a competition law perspective, because we are seeing a lot, of interrelationship between data, competition, and innovation, in this aspect. And last but not least, the Office, of Ofgem, which regulates some of the energy providers here in the UK. So we are really awaiting the tangible kind of outcome of this consultation, partly because how exactly they will react if, let's say, there's a huge data breach, doesn't matter whether it's AI or non-AI, whether it's a typical breach, and that particular breach really affect that particular sector, how ICO and these regulators will respond to the breach. So that's one aspect of it. And how the UK GDPR, post-Brexit, right, which still maintained a 4% of global annual turnover, will respond to that whilst quantifying the breach, and how exactly the resources of these regulators will have a joint investigation of the subject of that particular breach. And I'm very intrigued to really understand, in practice, how it works. And I think there might be certain ad hoc kind of investigation, which is not reported, not just in the context of the UK, but of course, in Singapore, they have been doing this. In fact, there are some cases where the Personal Protection Commission of Singapore has actually coordinated with Monetary Authority of Singapore. It's more like the FCA here in the UK, in terms of some of the breaches that are unreported in financial services prior to the PDPA 2012 enforcement a few years ago. So watch this trend, and this is something that an ongoing kind of relearning and refreshing, because if you're a DPO, especially like Amit, there are lots of things that oh my god, there's still these new things every day. So you need to tell to the business in a very specific way, hey guys, watch out for this, watch out for that. But of course, as what Amit highlighted, make it sustainable. Okay, in my view, don't overdo it, right? Because you have to understand your limitation. If you're a one-man show, you have to collaborate, right? If you have a very powerful tool, powerful technology, which I think that there's no powerful, imperfect technology so far, but try to improve it, And then if you need support, if you need actually help, as what Amit highlighted, ask your, colleagues, from others in the market. I'm going to be very biased because I'm a European Advisory Board member for IPP, but have this IPP certification. I'm not selling here, someone, but just that you keep on learning and relearning, because it's a huge and very sophisticated and trendy subject matter. Yeah.
Thank you so much, Norris. That was excellent. And frankly, I think Amit earlier had already promoted, the certifications for International Privacy Professionals Association. So I think it would not be treated as selling, because that's been already highlighted. Very quickly, I understand we have just 5 minutes left. Garima or Amit, would you like to comment on what Norris said, especially with regard to the last part of his conversation?
Sure. I could actually comment on that, because the entire conversation on data breach was actually very interesting. And I completely echo a lot of points that Norris made. I would just like to add a point to it from the industry perspective, because I think the bill in its current form goes in some detail to talk about data breach reporting and how it needs to be notified. I think the manner and form in which these data breaches need to be reported itself needs to be simplified, and the process itself needs to be more streamlined. So for instance, a data fiduciary should know that, okay, if a breach is happening, am I going to certain first to report, or am I going to this data protection board first to report? I think that needs to be clarified. Again, the point on harmonization comes back. And then I believe the manner and form of reporting will be a part of subordinate legislations later. But that is a point where the industry really needs to be widely consulted to make sure that it's easy to report breaches. That does not become a point of friction in itself, so that incident response efforts can actually be focused on more, as opposed to companies having to dedicate time and bandwidth to reporting it first, as opposed to trying to contain or mitigate the harm at that stage. So I think creating that ease would be really important. And then, of course, I can foresee that the data protection board and companies will have to work very closely together to make sure that any kind of harm is mitigated and the right steps are taken at the right time. So I think that would be really great. And I'll just give like a quick closing remark that I think what we really like to see in 2023 is for an enabling law actually to be finally passed. We've been seeing a law in the making for the last couple of years, and would be wonderful to see us getting closer to the finish line now. And this is an important year. India is assuming its G20 presidency, data economy, our goals for being a $1 trillion digital economy in a couple of years are complete top of priority for the government. So having an enabling law come out under these circumstances would actually be really beneficial for industry and for users alike. And I would just take a minute to qualify what I mean by an enabling law. We think about it, and I think it would mainly have three characteristics. One is for it to promote digital interoperability, as Norris had actually pointed out earlier, and create digital corridors of trust with other countries. So basically, India then should be talking to other countries, also building out these corridors on trust based on adequacy conversations, allowing for cross-border data flows to actually flow seamlessly, because that is going to be in the best interest of building India's own digital economy as well. I think the second characteristic would be, again, taking a point from what Amit mentioned, building a culture of accountability. And there actually, Salman, I would go a step further to say that this culture of accountability and compliance should not just be for private companies, but there should be a uniform applicability on private and public institutions alike. That I think would be really important. And through this, lead to bringing trust back in technology. It is only when this culture of accountability is seen at a wider scale will users have more trust that their data is safe, secure, and protected with adequate safeguards in place, and therefore bring the much needed trust back in technology and actually allow users to flourish the most, them to be at the good end of receiving products and services that they actually really need. So I think that would be broadly the three principles of an enabling law, and those would be my closing comments as well.
Garima, I think you've summarized it very well, and frankly, I think you've made my job a lot much easier in terms of giving a final summary comment. But I fully agree with you and actually endorse and the fact that you talked about developing that culture. I think I've talked about it almost for a decade now, even before the law was being considered, is like developing the culture for privacy. Developing the culture for, because in India, unfortunately, we are so callous with our data that we at times do not realize where and what we are sharing. And I think more than having the legislation, more than having all these sophisticated, mechanisms in place and everything, unless and until we sensitize people, whether it's the consumers, whether it's the stakeholders themselves, or whether it's the government or the regulator, and right across, the industry and government, as a society, as a digital society, if you're not able to sensitize people and make them aware of their rights and their liabilities, I think we fall short. So I fully agree with what you have said. And I think just quickly, I'll request Amit to maybe finally give us concluding remarks, and we'll just wrap up. Amit,
Sure. Thank you, Salman. So I think my closing remark would be that India should focus on creating a law which is just not an eyewash. It should ultimately be able to withstand the global scrutiny. It should be at the same level where any other lawmaker in any other country where the law has been passed, say, for example, UK or Ireland or Japan or South Korea, and be able to say that, yes, India is a safe country where data of my country's citizens and residents can be safely transferred. So that, in the Indian companies do not face those difficulties which they have been facing so far. So they should be focusing on that, because that's the whole point, to make life easier for the companies. Now, second point would be, as you rightly said, Salman, sensitizing the consumers, the actual data owners, data subject, that this is their right, what their rights will be, and how they should be able to exercise their right in the new scenario. Government has empowered them by enacting this law. How they can use that to ensure that they are safe and their family is also safe going forward in the new digital world.
Excellent. Thank you so much, Amit. And picking up from what you actually said, and also sort of what both Norris and Garima had said, the fact that we're talking about sensitization, and just before we conclude, I'm happy to announce that based on the interest that we have received, and the fact that a lot of people wanted to join and could not join because of various constraints or time limitations, we have actually decided to extend this and convert this global virtual roundtable into actually a series of events spanning over the next month. So we'll be actually conducting similar roundtables and fireside chats, and actually other group discussions over the next 4 weeks. So we will have hopefully a weekly round, and where we can bring in different stakeholders. And to your point, Garima, especially about your expectations from 2023 and your wish list. I think I just hope some of the government people are listening, or some of the regulators are listening. But if they are not, we'll try and bring in the next session. We'll try and bring somebody from the government to try and help them understand what are the practical implications. And to be very frank, the way you summarized it, having an enabling law, what it means, and how it would make the big difference, not only for the industry, but for the country, where we are aspiring to be a global leader in the near future. So once again, on that note, I'd like to thank each one of you, especially for all your time and taking up time from the busy schedule and for sharing your thoughts. I'm sure our audience benefited extensively from your experiences and from what you have sort of shared with us here today. So thank you once again, everyone, and best of luck for the near future.
Thank you so much, sir.